Hi there, Jeff at Family Law Decisions, Mackenzie Friends and Paralegals. One of the questions we get asked is, what is a non-molestation order? A non-molestation order stops someone from contacting you, harassing you, pestering you, or causing some kind of nuisance towards you. Sometimes people talk about restraining orders. Restraining orders are really when the police are involved initially, and then the magistrates' courts will issue a restraining order and there are bail conditions. A non-molestation order is really a civil matter, but with criminal sanctions. If someone breaches a non-molestation order, then there are penalties, which could be fines, perhaps of initial breach if it's fairly minor, but also there's a possibility of imprisonment for up to 5 years. So it's a serious matter if you receive a non-molestation order, and you should not breach it in any way or be seen to be breaching it in any way, or allow one of your friends or family to contact the person who's issued the non-molestation order. There is no court fee for an application for a non-molestation order, but you do need to make sure that your application is prepared carefully. For example, you need to fill out a form FL 401 correctly. You will need to do a witness statement with a statement of truth. That witness statement will need to provide details of any incidents that have happened. Also, it will need to explain why that person that you're speaking to, that you're asking a non-molestation order for, is a associated person, and there are specific rules on what an associated person would be. What is the process regarding a non-molestation order matter? So an application is made on an FL 401 and a witness statement is provided to the court. The court can then list it as an urgent matter, where both parties will attend the court, or the court will list it as an urgent matter without notice, which means that only the party that's made the application will attend court. If it's not an urgent matter from the court's point of view, then it will be listed for normal proceedings, which could take weeks or months to get into court. Both parties will be notified of the date. The parties that's received the non-molestation order application will be given a copy of the application and the witness statement that has been made against them. If it's an urgent matter, then the court can make a non-molestation order there and then, and that will be served by the court bailiff or by the court on the other side. At some stage, the party that's received the non-molestation order will be given an opportunity to attend court and to provide their view on the application. On the return hearing, there could be an agreement that there should not be a non-molestation order, or there should be an undertaking, a formal promise to the court, or that the party that's received the non-molestation order may not wish to oppose it. That would be the end of the non-molestation order matter in this Family Law Act proceedings. The matter will then normally be listed for what's called a pre-trial review hearing, where the court will want to ensure they've got all the evidence, perhaps police disclosure, any other witnesses that may have written statements on behalf of the applicant or the respondent. Once the court believes it's got all the information it requires from both parties, it will be listed for a contested hearing. At the contested hearing, cross-examination questions will be asked of both parties. The judge may ask questions, any witnesses may be asked questions. At the end of the contested hearing, the court will make findings within a judgment, which both parties will hear in the court, or could be provided afterwards in a written judgment by the judge. If a non-molestation order is already in place and the judge decides that there needs to be a continued non-molestation order, it needs to be extended, and the judge could, for example, reissue a non-molestation order for another year. What evidence is needed for a non-molestation order? That's a question that we're asked regularly. The evidence that you've got should be put into a witness statement. You can get a template from the gov.uk site, FL401T, or you can draft your own witness statement with a statement of truth, and sometimes that's a lot easier to deal with and to put your case forward to the court. Your evidence in the witness statement should contain details of your relationship with the person that you're asking the court to make a non-molestation order against. Your witness statement should contain as much detail as possible, but you also have to bear in mind that it could be an urgent application, so you may not be able to put everything down into your witness statement. Don't worry about that. You can provide more information later on. However, any evidence that you may have, such as texts, emails, which can be screenshot and put into exhibits, that will be very helpful to the court. Any photos that demonstrate there's been a problem, that obviously will be helpful. And also, if you do have any witnesses who can corroborate what you're alleging, then of course that will be of great assistance to the court. Other evidence you can provide are letters from a GP, a letter from a GP, domestic violence support worker, something from the police, perhaps an email to say that they're investigating an issue that may have arisen. I would advise, once you have the evidence that you think might be helpful, historical and of a more recent nature, that if you speak to someone who's got the ability to assist you in this with the experience and knowledge, then you're going to find it a lot easier to make the right argument for the court first time, which will save your application being rejected or not proceeding as quickly as it could do. Another question we get asked is, what happens if there is a breach of a non-molestation order or an alleged breach of a non-molestation order? So the first thing to do is to contact the police. If there's a breach of a non-molestation order, it is a criminal matter. It is the police that will take action. Because a breach of a non-molestation order is such a serious offence, the sanctions for it are fines, perhaps, but it can go up to imprisonment for 5 years. If there is a breach of a non-molestation order, then you can show the police a copy of your non-molestation order, which will assist them in their investigations. Sometimes people are worried about incidents happening when they're out of the home, so we would suggest, if there's a possibility that you may have to call the police when you're out of the home, that you carry a copy of the non-molestation order with you. What happens if you're unsure if a breach of the non-molestation order has been made? Well, the key thing to do is to look at the order carefully and make sure that if there's a possibility of a breach, that you've checked it carefully and that it does fall within the parameters of that clause in the non-molestation order. Why are non-molestation order applications rejected? The court may reject a non-molestation order application because it's not been filled out to the correct standard. And that could be that items are missing, or in the form, or the witness statement is not sufficiently strong enough to provide a reason why the court should make a non-molestation order. Once you get to court, with the help of the judge, it may be agreed that a non-molestation order is not really necessary. The court could then make an undertaking, or ask one of the other party to make an undertaking, which is a formal promise to the court not to do something in the future. Or there could be cross undertakings if the other party is making allegations. So cross undertakings is when both parties will do a promise to the court, which is called an undertaking. If one party makes a non-molestation order application, on receipt of that non-molestation order application, perhaps the other party will say, well, actually, I want a non-molestation order. This is not a usual response to a non-molestation order that's been received, but it can happen. And so when it gets to court, the court may look at this and decide that there should be non-molestation orders for both parties, and that would be called a cross non-molestation order. Can I oppose a non-molestation order? Quite often when we're advising people, we'll look at the situation. If there are children involved, then that may mean that you take one direction in how you approach a non-molestation order made against you. Most parents who receive a non-molestation order are more interested in seeing their children rather than getting into a big fight over whether or not there were issues in the past in the relationship between them and the other partner. So what we often suggest is that you should concentrate on the children matter, making an application for a child arrangements order, which can then change the non-molestation order if necessary. When you get to court, then you can make a case that you don't want to oppose the non-molestation order on the basis of no admissions and no findings. So the court hasn't decided that you've done anything wrong, and you've not admitted to do anything wrong, but what you're doing is you're taking a practical approach that you want to end proceedings now in this non-molestation order matter, because it's a sensible approach to end proceedings rather than go into a big convoluted battle which could take weeks and months to come to some sort of any sort of resolution. If children are involved, then it's important to concentrate on the children matter rather than on non-molestation order matter, because the reality is if a non-molestation order is in place, then the likelihood is you don't want to have a relationship, you don't want to contact the other party, and the only reason you do have to contact the other party or the parent is because you need to make arrangements for the children. If you make a child arrangements order application and it gets to court, then they can amend the non-molestation order so you can actually contact the other party to talk about the children, make arrangements for contact and other issues that may be important for you regarding the children. If you receive a non-molestation order against you, or an application for a non-molestation order against you, then what you don't want to do is be spending the next 6 months in court opposing that, and maybe with the risk that findings will be made against you. It's far better to make an application for a child arrangements order, get the court to concentrate on your relationship with the children rather than dealing with allegations in the past through a non-molestation order proceedings in the Family Law Act. It's important to note that a non-molestation order can be varied, amended by the court in child arrangement order proceedings. So don't worry or panic too much, because there is flexibility to change the non-molestation order later on within child arrangement order proceedings. Please note that legal aid is available for people on low income. So we would always suggest, if you're on low income, that you check with the legal aid solicitor to find out if you're eligible for legal aid. There is also on gov.uk there's a page or pages on legal aid which might be able to assist you in obtaining a solicitor who can represent you.